Welcome to the deep dive. So imagine this scenario. You buy a piece of what looks like prime commercial land. You're relying on what the seller told you specifically, that it's got, say, 580 feet of highway frontage and sits on maybe 1 million cubic yards of valuable gravel.
Right, key selling points.
Exactly. But then, turns out the seller was just honestly mistaken. The frontage is quite a bit shorter, and the gravel, practically non-existent. So what happens? Do you just, eat the loss?
No.
Or can you actually tear up the whole deal?
That's the tightrope we're walking today. We're diving deep into this defense innocent misrepresentation. We're looking at how courts handle these situations where the seller didn't lie intentionally, but key facts were just wrong, especially in big deals like land sales.
We're using a specific case for this, right?
Yeah, the landmark Alaska Supreme Court case, Cousineau v. Walker, it really changed the game.
Okay, so our mission today is to figure out how a buyer, even a professional one, mind you, can potentially void a contract because the seller made an honest mistake. We're going to really break down the court's thinking element by element because they set this, well, kind of radical new standard.
They essentially said a buyer could mess up their own due diligence and still win.
Unless, and this is the kicker, unless that failure was, and I'm quoting here, wholly irrational, preposterous, or in bad faith.
That phrase really is the heart of it. And to understand how they got there, we need to follow this specific three-step analysis the court used. It checks for actual reliance, then materiality, and finally whether that reliance was justified.
And this structure is how they flipped the script on the lower court.
Exactly. It led them to overturn the trial court and, frankly, redefine how we think about a buyer's responsibilities in real estate deals.
All right, let's start with the basics. When a contract goes wrong like this, the goal is often rescission, right? Undoing the whole thing. So what's the basic legal idea behind innocent misrepresentation? How does someone prove they should get to walk away?
Well, the general rule, and you see this in lots of cases in the restatement of contracts, is that, yeah, even an innocent misrepresentation, meaning the seller truly thought they were telling the truth, can be enough to rescind a contract.
So it's not about punishing a liar, it's about fixing a fundamentally flawed deal.
Precisely. The idea is to put both parties back where they started before the contract was ever signed. Restore the status quo, as they say.
Okay, but how does a court draw the line? I mean, not every little mistake lets you tear up a contract. What are the specific things a buyer absolutely has to prove?
Right, there's a clear three-part test. First, the buyer has to show actual reliance. Did this specific buyer actually rely on that false statement when deciding to buy? It's subjective to them.
Okay, so did they believe it and act on it?
Yes. Second is materiality. Was the statement objectively important? Would a reasonable person thinking about buying that property consider that fact important? This weeds out trivial stuff.
Makes sense. And the third?
The third, and often the trickiest, is justifiable reliance. Was the buyer actually entitled to rely on what the seller said? Or, should they have reasonably checked it out themselves?
And that third one sounds like where Cousineau v. Walker really comes into play. It seems like the perfect case to see these elements clash. So let's dive into it, following our structure.
Yeah.
First, what are the legally dispositive facts?
Okay, so Walker owned this 9.1-acre commercial plot in Alaska. When it was listed for sale, the seller's agent made a couple of key claims repeatedly. One, that it had 580 feet of highway frontage. Two, that it contained a minimum 80,000 cubic yards of gravel.
80,000. That sounds like a lot.
It is. And interestingly, an earlier listing had apparently claimed over 1 million cubic yards. So 80,000 was already a step down, but still specific.
Okay. And the buyers?
The buyers were the Cousineaus. And this is important. They weren't just anybody. They were contractors specifically in the gravel business. They bought the land for $385,000.
Ah, so the gravel claim would seem particularly relevant to them. What happened after they bought it?
Well, after closing, they discovered two major problems. First, the highway frontage wasn't 580 feet. It was only 415 feet. And second, the big one for them. They started extracting gravel and ran out after removing only about 6,000 cubic yards.
Wow. 6,000 instead of a minimum of 80,000.
Exactly. A massive difference. So after paying about $99,000 towards the purchase price, they stopped payments and sued for rescission.
Okay, that sets the stage perfectly. And what was the core legal issue that went up to the Supreme Court of Alaska?
The precise legal question was, were the Cousineaus entitled to get out of the contract rescission and get their money back restitution because of these false statements, even though the seller, Walker, hadn't intentionally lied? It was about innocent misrepresentation.
Got it. So what rule of law did the court apply to answer that question? Can you state the full rule and break down its testable elements again?
Sure. The court applied the rule that a contract can indeed be rescinded for innocent material misrepresentation, but only if the buyer proves all three of these elements. Number one, actual reliance on the statement. Number two, the statement was material to the deal. And number three, the buyer's reliance was justifiable.
And crucially, the trial court, the first court that heard the case, found they failed on all three counts.
That's right. The trial court said nope, no actual reliance, not material, and definitely not justifiable reliance. They basically shut the door on the Cousineau.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step, just like the Supreme Court did. How did they apply the first element, actual reliance? Did the Cousineaus really buy this land because they believed those claims, especially about the gravel?
Yeah, the Supreme Court found this part pretty straightforward, actually. They looked at Wayne Cousineau. He wasn't just buying land, he was in the gravel business.
Right, that seems key.
It was. He first saw the property advertised with that $1 million in gravel claim. Then you look at the paperwork. All the sales documents, the deed of trust, they all had specific clauses about transferring gravel rights.
Okay, so it was baked into the deal itself.
Absolutely. But the real clincher, the court said, was Cousineau's actions right after buying the property. What's the first thing he did? He went out and spent $12,000 on gravel scales and immediately set up contracts to start removing the gravel.
So he was acting exactly like someone who bought the land for the gravel.
Precisely. Based on those undisputed facts, the Supreme Court said the trial court's finding of no reliance was what they call clearly erroneous, just wrong. They found reliance existed for both the gravel and the highway frontage claim.
Understood. Okay, that's element one met. Now let's turn to the second element, materiality. You said reliance is subjective, but materiality is objective, the reasonable person's standard. How did the court figure out if the shortage of gravel and that missing highway frontage were objectively important?
Right. The sub-rule here is whether the fact is something to which a reasonable man might be expected to attach importance in making his choice of action. Basically, is this a big deal or just a minor detail? It stops people from trying to void contracts over, paint colors they don't like.
So was losing nearly 170 feet of highway frontage on a commercial lot, or finding almost no gravel when you expected tens of thousands of yards, was that objectively important?
The court said yes, absolutely, as a matter of law. They pointed out that the seller's own agent had listed the gravel as one of the property's best points, a selling point. That shows even the seller thought it was objectively important.
Good point. What about the frontage?
And with the frontage, the buyer got less than 3/4 of what was advertised. On a commercial property, highway frontage is often critical for access, visibility, value. So yes, the Supreme Court concluded both misrepresentations were definitely material. Any reasonable person would care about these things. Element 2, met.
Okay, here we go. Element 3. This seems to be the core conflict, where the big policy shift happens. The trial court essentially invoked caveat emptor buyer beware. They said, look, Cousineau, you're an experienced gravel guy. You could have checked public records for a survey. You could have paid for an engineer's report on the gravel. You didn't do your homework. How did the Supreme Court handle this third element, justifiable reliance? Why did they protect a buyer who, frankly, seemed to drop the ball on due diligence?
This is really the crux of the decision, and it's where the court made waves. They acknowledged up front that, yeah, Cousineau probably showed poor judgment. He didn't do the checks an experienced person might normally do.
So they agreed he messed up.
They acknowledged the lack of diligence, but then they pivoted. They explicitly said that the old doctrine of caveat emptor buyer beware is rapidly receding when it comes to real estate. It's becoming outdated, much like it already had in the law for selling goods.
Wait, so they're saying the rules for buying land should be more like the rules for buying, I don't know, a toaster, where you can generally rely on the box description.
That's pretty much the analogy they drew, yeah. They felt the legal standard needed to catch up with modern commerce. The old rule put all the risk on the buyer, making them constantly suspicious. The Supreme Court decided to adopt a new, much higher standard for when a buyer loses their right to rely.
And what is that new standard?
They held that a buyer of land who relies on an innocent misrepresentation is barred from getting rescission only if their failure to discover the truth was wholly irrational, preposterous, or in bad faith.
Wow. Wholly irrational or preposterous. That's a really high bar. So Simple negligence or poor judgment isn't enough anymore.
Exactly. That's the radical shift. The court basically said, sure, Cousineau could have done more. Maybe he should have done more. But was his failure to double-check the seller's explicit material statements about gravel and frontage completely irrational? Was it preposterous? No. He was relying on what the seller told him.
So the message is, sellers, your words matter. Even your innocent mistakes can blow up the deal unless the buyer's reliance was just totally nonsensical.
That's the takeaway. The seller made the claims, so the seller bears more of the risk if those claims turn out to be wrong, even innocently. The buyer generally gets to rely on material statements unless doing so flies in the face of all reason or suggests bad faith. Element 3, met.
Okay, so after finding the buyers met all three elements, actual reliance, materiality, and justifiable reliance under this new standard, what was the court's final conclusion?
The Supreme Court reversed the trial court's decision and remanded the case, sent it back down. The contract was rescinded because of the innocent misrepresentation.
Meaning the Cousineaus get their money back.
Yes, they were entitled to restitution, getting back the $99,000 they had paid towards the property. But, and this is really important, the court didn't just stop there. They applied principles of equity to make sure the outcome was fair to both sides.
The set-off you mentioned earlier.
Exactly. It's called recoupment, or set-off. The court ruled that the seller, Walker, was entitled to get paid back for certain things, specifically for the fair value of the 6,000 cubic yards of gravel the Cousineaus did manage to remove before realizing the shortage.
Okay, so they had to pay for what they actually got.
Right, and also for any damage they might have caused to a building on the property, and importantly, the fair rental value of the property for the entire time they possessed it while the dispute was ongoing.
That seems crucial. The goal is to unwind the deal, but not let the rescinding party get a free ride or keep benefits they got from the flawed contract. Let's talk more about that policy shift then. It's a huge move away from caveat emptor. Why did the court feel this was necessary? What was driving this change?
Well, the court pointed to a clear trend in the law generally. Historically, maybe land deals were simpler. You could walk the land, see the boundaries. But modern real estate is complex. You've got zoning, surveys, environmental reports, subsurface rights. The court felt the old buyer beware rule just didn't fit anymore.
And they explicitly connected this to how we treat sales of goods.
Yes, very directly. They highlighted the Uniform Commercial Code, the UCC, which governs sales of goods. Under the UCC, if a seller makes a factual statement about a product like its features or specs that creates an express warranty, the buyer can usually rely on that warranty.
So if the box says the widget does X, you can assume it does X without having to take it apart first.
Pretty much. And the Alaska court essentially said, why should land be different? They argued that apart from tradition, there's no logical reason to treat a seller's factual statement about land any differently than a statement about commercial goods.
That's a really strong statement. It basically elevates the seller's innocent representations about land to the level of an express warranty. The burden shifts significantly to the seller to make sure their material statements are accurate.
It does. The underlying policy seems to be about risk allocation. Who is in a better position to know the truth about the property? Usually the seller. So if they make a material misstatement, even innocently, they shouldn't automatically get to blame the buyer for simply believing them unless that belief was, again, completely irrational or in bad faith. It favors good faith reliance over forcing exhaustive, suspicious investigation in every single case.
Okay, this is incredibly helpful. Now, to make this really practical for listeners, especially if they're, say, studying for an exam or analyzing a similar situation, how would you synthesize all this into a clear step-by-step checklist?
Absolutely. If you're faced with a potential misrepresentation issue leading to rescission, here's a 3-step diagnostic checklist based on Cousineau. First, issue spotting. Pinpoint the specific statement. Did the seller or their agent make a false statement of fact? Remember, even an innocent mistake counts. It can't just be puffing or opinion.
Okay, identify the misstatement of fact.
Second, apply the test. You have to rigorously apply that 3-pronged rule from Cousineau. 1. Reliance. Ask, did this buyer actually rely? Look for evidence. Did they adjust their plans based on the statement? Did they buy special equipment like the Cousineaus? Is it mentioned in the contract? 2. Materiality. Ask, was this fact objectively important? Would a reasonable person care about this discrepancy when deciding whether to buy this type of property? 3. Justification. This is the Cousineau twist. Ask, was the buyer's reliance wholly irrational, preposterous, or in bad faith? If the answer is no, even if they showed poor judgment or were a bit negligent in checking, their reliance is likely justified under this modern standard.
So justify reliance unless it's utterly absurd.
Pretty much. Then third, determine the remedy. If all three elements are met, the primary remedy is rescission, canceling the contract, and restitution, getting payments back. But, and don't forget this, immediately consider the set-offs, the recoupment.
Right, the fairness adjustment.
Exactly. The court will adjust the restitution amount to account for any benefit the buyer received while they possess the property. Think fair rental value, payment for resources extracted, like the gravel, or compensation for any damage caused. The goal is a true return to the status quo, not a windfall for either party.
Okay, let's try to wrap this up then. This deep dive really highlights a major shift. In modern land deals, what a seller says, even innocently, carries enormous weight. It acts almost like an express warranty. So if you're the buyer and you can show the statement was materially wrong and you relied on it, the law generally has your back.
Unless your reliance was just completely off the wall, unreasonable.
Right. The strict buyer beware days seem to be fading in this context.
But what's also really fascinating and fair, I think, is how the court handled the aftermath. They allowed rescission, yes, but they meticulously calculated those set-offs. The Cousineaus had to pay for the gravel they did get.
It prevents the rescinding party from being unjustly enriched by the very contract they're undoing. Which brings us to a final thought for you, the listener. Cousineau sets a high bar for protecting buyers who rely in good faith. But that set-off rule is critical for fairness. Makes you think. When a court unwinds a deal, how far should it go to adjust the finances? If you rescind a lease after living somewhere a year, should you owe back rent for that whole year, even while you were fighting the validity of the lease itself? Where exactly is the line between restoring the status quo and potentially penalizing the party who won the rescission case? That's the complex, equitable balancing act courts like the one in Cousineau have to perform.